Welcome back to the Law News Network, everybody. I'm Aaron Keller. I'll be with you for the rest of the afternoon here. The jury is now deliberating the fate of John Valerio out of Nevada. He's accused of first-degree murder and has been convicted of first-degree murder some 29 years ago. The original crime happened 31 years ago. Because the U.S. Supreme Court requires bifurcated trials when the state seeks the death penalty, the first two trials resulted in the following. The guilt phase, in other words, the conviction, stands, but the penalty phase, the death penalty decision, the death penalty sentence, was overturned on appeal by the Ninth Circuit Court of Appeals. So this defendant sits in court being a convicted man. He's guilty. This retrial only focuses on what his punishment should be, and those are the arguments we just heard from the defense and the prosecution. Attorney Michael Starr Hopkins is along with us once again here on the Law News Network. Good to see you back.
Thanks for having me.
So I thought that this was a really interesting legal conundrum because I can't think, at least off the top of my head, of a case where another man has been on death row for 29 years and then because of an appeal this many years later gets another bite at the apple. And I have to lay part of the blame at the state of Nevada because the U.S. Supreme Court ripped this phrase, depravity of mind, out of the jury instructions, saying that they were too vague on their face, and the state of Nevada kept using them for 15 or so years. Well, no wonder all these cases are being overturned on appeal. The U.S. Supreme Court says you can't use the language, you need to snap with it, right? I mean...
And then you saw the Ninth Circuit come in and say, you guys have to go back and redo this. And so, like you said, it's something I haven't really seen before, and it poses an interesting dilemma because you have an individual who's been sitting on death row for such a long period of time. He now doesn't look like the person who was tried. The age has caught up with him, and it appears as if, there's, an opportunity for his life to be spared.
Now, what's surprising about the scenario is that the evidence, the mitigating circumstances, the things that would suggest his life should be spared, okay, are mostly things that he has done in the last 15 years of his life,
Absolutely.
Approximately. The prosecution's been pretty clear. Hey, look, you were a bad guy the first 15 years or so you were incarcerated on this crime. You were a bad guy before you committed the crime. We're supposed to all of a sudden give you the chance at parole based on becoming a better man now that that you're over the hill and you're in your 50s?
Yeah, I mean,
it creates just such an interesting conundrum, and I know that that's not what the process was necessarily designed to do, but that's the upshot of the process.
Yeah, it was never meant to go back and provide a second opportunity for someone. This case has been a little different than I think what anyone could have imagined because of those factors, because of the fact that now he has reached out to, I believe, his daughter and formed more relationships and has supposedly grown as an individual. But when you look at the violent nature of the crime itself, it's hard to imagine that any jury would let him out on parole. I think this really comes down to a question of whether he'll get the death penalty or whether his life will be spared and he'll spend the rest of his time in jail.
That would seem to be the argument that the state was pushing for. And they said right before the closing argument rebuttal wrapped up, you can't take this chance, jury, of letting this guy have the chance of getting out at some point, and then he runs across somebody who triggers bad memories. He had a bad relationship with his birth mother. The attack by all accounts was just incredibly violent. The prosecution's saying, well, it's going to trigger that.
Yeah, I thought that was a really powerful moment when the prosecutor put that on the jury and said, if this guy goes out and kills again, basically, do you want that on your conscience? And I was a little surprised not to see the defense object to that, because usually, you're not allowed to put that on the jury. You're obviously not allowed to have the jury step into the shoes of someone else. But even putting that on the jury and basically saying, if he kills again, it's because you let him out, it's usually objectionable.
I mean, there are so many cases that I look at and say there should be an objection, and then there are sometimes when I see the prosecution objecting a little too much during closing arguments, because in argument you get a little bit more wiggle room. It's argument, not evidence.
Absolutely.
And the judge instructs the jury that you can throw everything you heard in the argument out the window if you want, back in the jury room, and look only at the evidence. Okay, and I remember one time when I served on a jury, I basically had to take that tactic.
Yep.
So, but to your point, I think that the closing argument rebuttal started out very, very well.
Oh, absolutely.
I thought it was extremely good. I think he went off the rails a little bit and argued a little bit too much in the second half.
Yeah.
And I wonder if he lost a few people there.
I think he did. I think that's always the problem when you argue in an emotional manner without notes. You know, he had a good pace going. He was going point by point and really relating to the jury. But towards the end, you could see him kind of lose his place and start to argue from a place that wasn't emotional, but seemed more of kind of just reaching for straws and trying to, you know, throw everything against the wall and see what stuck. And so I think that's when you saw that kind of comment that may have lost a jury or two.
Well, it's in the hands of the jury now, and while we wait to see if a verdict is forthcoming, I want to go back and replay for you the defendant's allocution. This was a statement that the defendant made last Thursday evening, at least evening on the East Coast here, towards the late afternoon hours on the West Coast where the case is being heard. This is the defendant basically speaking in an attempt to save his own life. It's an allocution, so that means that it's done without questioning. The defense attorneys do not ask the defendant questions. The prosecutors don't get a chance to cross-examine him, and it's not under oath, interestingly. So bottom line is this was just shy of 7 minutes. Let's listen to the defendant in his own words.
Good afternoon, ladies and gentlemen of the jury. I wanted to talk to you first and foremost because I wanted to talk to you and look at you and let you hear my voice. And of course, I also thought that if I was sitting in this chair, I would probably want to hear from me. So for those two reasons, I wanted to speak to you. First and foremost, there's not a day that goes by that I'm not remorseful and that I don't think of Miss Blackwell and the things that happened in 1986. I want you to know that. Okay, let's see here. I didn't write a statement because there were a couple of things I wanted to talk about, so please bear with me. My family, Ms. Blackwell and her family were also affected by this, and I want to apologize to them, Ms. Blackwell's friends, my family and friends who have stood by me throughout my incarceration, and I know it hasn't been easy for them. This has been a lot for a lot of people. The last 31 years, I've heard a lot of talk about how I changed or how I haven't changed. There's been discrepancy about that. I feel that I have, specifically the term mentally, physically, and spiritually. Those three elements are essentially what I've taken in one day at a time. And it starts with mentally. The reason it starts with mentally because if you're reading spiritual, if you're concerned about being physical and working out and exercising, if you're not mentally intact, the rest they don't go together. So I started with that. I took an assessment of myself and the things I've done in the first 21 years of my life when I first got incarcerated. I think it's probably not very difficult to see that I was a menace. I mean, there's no other way to put it. I made a lot of mistakes. I did some things right, but I did a lot of things wrong. Now, the past 31 years, prison does a lot of things for you. It gives you time to take a look at yourself every day in the mirror when you shave, every time you have a conversation with somebody. And you can either do one of two things. You can either change or you can remain the same. A good friend of mine once told me, her mother actually told her this, and it was a really good quote. She said, my mom used to tell me when you're down on your hands and knees, probably the best thing you can do is pray while you're down there. I did that, and I'm still doing that. I don't run around with a Bible telling everybody how I'm religious or how they need to change their lives, but I do read spiritual material, things that are positive. I make better choices today. And to me, making better choices, things get easier when you make better choices. I mean, rules, various things that I've done throughout my incarceration, they're because of those things. My way of thinking, I try to associate myself with positive people, encouraging people. I try to be encouraging, I try to be positive. And every once in a while I realize that I've made a difference to somebody. I don't do it for self-acknowledgement or a tap on the back, but it does feel good every once in a while when somebody acknowledges that you made a difference for them and to them. I've done that in prison, I've done that with pen friends, I've done that with my parents. They've seen a change in me. I know I've changed, and I haven't changed because I knew this hearing was coming 15 years later. I haven't had a lack of charges for 17 years because I knew that I was going to be in front of you making this statement someday, and, well, I want to convince them, look at what I've done here. That's not why I changed. I changed because I'm being accountable for all of the things that I've done. I've changed it, as I explained. When I was at my lowest, there was only one way up. I had to make changes. There was a good person in there. Was there a good person the first 25 years? As I said, I did a lot of things right, but I also did a lot of things wrong. So I'm being honest about that. I also wanted to talk about my plans for the future if at any given time I'm ever given the opportunity for a chance at parole. I'll have to continue to do the things I told you about. Because if I don't, that chance will never take place. But I won't do those things to make it to a parole board to please them. I'm going to continue to do those things just like I've continued to do for the past 31 years when I didn't see that there was a chance at a parole board somewhere down the line. Because that's who I am. It's not a facade. There's nothing fake about that. That's just what I'll continue to do. And I'll do my best not to let anybody down. If that ever happens somewhere down the line, I don't know. That's going to be your decision. Okay, so I think I'm going to wrap this up because for the most part, like I said, I wanted you to hear my voice, see my face, and speak to me. I've been over there for a couple of weeks, just taking notes. And I'm going to wrap it up for now. I'm grateful for your patience.
That was the defendant's allocution, where he sits in the witness stand but is not faced with questioning from his own attorneys. He's not cross-examined. He's not under oath, but he gets a chance to say something to the jury. So, Michael, I think that's the first time you saw that. What was your immediate reaction?
You know, as a defense attorney, that you can't ask for much more from a client when allocuting. You know, he gave an honest, I think, effective explanation of where he was then and where he was now. The only thing that kept coming into my head was the brutal nature of the crime itself and how the jury is going to be able to look at, you know, the brutal nature of that crime and juxtapose it with this individual who's sitting before him now talking about his spirituality and his growth. Those two images don't go together, and I think it's going to be really interesting to see how the jury reacts to that.
I agree, and when I watched that last week, I thought that he did a phenomenal job with the allocution. I think that he wasn't reading a script. There were some common elements in it that we see in many of these sorts of discussions, but I don't think that there was anything in there that came across as insincere.
No.
That said, the question is whether the jury wants to put weight on that or whether the jury is going to take the prosecution's advice and say, look, it's not about the guy he's become, it's about the guy he was. And they're trying to take the sting out of this so-called second bite at the apple, which I can't recall another person on death row getting in quite this manner, going in front of a jury twice to determine whether he should be sent to death row. I think the prosecution's really trying to get him to dial back and say, look, this guy, in one of the lines, it sticks out in my head, the prosecution said, light sentences are for people who make their first mistakes. And we hope that they reform themselves. He had other violent crimes leading up to this murder, and we can't sit here now and believe that he's suddenly a different person, because his core character when he's out on the streets is one of violence. That's what the prosecution was really trying to get the jury to believe. And if the jury puts stock in that argument, what the defendant said on the stand really isn't going to carry a lot of weight.
That's true. And when you look at the escalation of the crimes, that indicates a likelihood to commit later crimes. And it seems like the only thing that stopped him from committing more crimes is the fact that he was locked up and unable to do so. I think one thing that the jury's really going to look to, when you heard that allocution, he looked like he could be any soccer dad on the sidelines, any neighbor. And I think that the idea that someone who looks so calm and looks like they could be, anyone's neighbor could commit such a heinous crime is really going to sit in the back of the jury's mind and say, what's stopping him once he gets out from doing something like that again? Because that really does go to a core character issue.
Part of me wonders if this is the sort of case that's ripe for a hung jury. Because my guess is that there's at least one person who's going to see it the prosecution's way, and at least one person's going to look and say, you know what, even if I sat here 29 years ago at the original trial and thought he deserved the death penalty, I'm not sure if he deserves it today, and maybe we should do something different. Now the question is how the jury might deal with those opposing views. The jury might look and compromise and say, well, let's just do life in prison without the chance for parole, because they have that choice too. Or they have the other two ends of the bookshelf here. They could say death penalty, or they could say life with the chance of parole. And part of me wonders, and you're sort of nodding in at least semi-agreement, this might really stick back in the jury room. There could be some friction.
Yeah, I would hate to be on this jury because, you look at how the death penalty is trending, and we're seeing less and less death penalty convictions. That's kind of how it's going across the country. Even in states like, Texas, which execute much more than other states, we're starting to see less and less of it. And so, I would be very surprised if you saw a jury where everyone agreed and we got some sort of sentence quickly. I think this is going to drag on because, just like you said, there's going to be someone who is very adamant about, given the heinous nature, that that he should get the death penalty. And I think on the other end, you're going to see people who say, it looks like he has reformed himself. Maybe he has changed. Maybe life in prison is the right sentence. I can't see them giving him parole.
That would, I don't know if I see it either, but then again, I've seen stranger
much,
things in life. So, but that chance even is on the table. The fact that it's on the table, just talk about a major change in circumstances for this particular defendant. He could go, in theory, from death row to the possibility of parole. And see, now that's the key word that the defense was playing up, was possibility. You can send this to the parole board, and they're the real experts at examining inmate behavior, and they might choose not to let him out. I don't know if I necessarily believe that that's a clean argument, because in Nevada, they tend to parole people based on behavior more than they do on remorse, and we heard that in the O.J. Simpson parole hearing.
Exactly.
So we know that to be the way Nevada operates. If you're on good behavior in Nevada, you're going to get out of prison. Okay, it doesn't matter whether you feel sorry or not. They said that. Okay, so I thought the defense's argument was a little bit disingenuous in that sense, but they at least registered the argument.
They did.
The jury can chew on it.
I thought the most powerful moment in that allocution was where he talked about the fact that for the last 17 years he's tried to stay out of trouble. He was doing these things knowing, or at least believing, that there was no chance for him to get out. And so, that I think was an effective argument to show that, he was doing it because he wanted to grow himself, not because he thought there was a chance that he could get out.
It seems that his ultimate argument there is that he didn't want to spend what he presumed the final years of his life just wrapped up in rage and bitterness. So if that indeed is his outlook, then again, it seems sincere to me. The question is whether or not he should be let out free as a bird at some point based on that, and that's a decision that I'm glad that I don't have to make.
Me too.
So let's listen to some of the beginnings of the prosecution's closing arguments here. Again, the prosecution went first. in this particular closing. Then the defense went, and then the prosecution had a rebuttal. The prosecution always goes last because the prosecution has the burden, but here they had a little bit of a preview. So let's start our analysis of the closing argument with the very first words out of the prosecution's mouth.
Ladies and gentlemen, as I drove into the courthouse this morning, I looked at the sunrise coming up over the mountains. There was a low blanket of clouds covering the sun, making those clouds look golden. It was a beautiful thing to look at and behold as I drove into work today. And I couldn't help but think about the dark night of September in 1986, when Karen was stabbed repeatedly. 45 times she was stabbed. There had to have been a thought between stab wound number 1 and 45 of hope for a new day. There had to have been a thought of somehow being able to survive this attack, to make it to see another sunrise. There had to have been a plea or a desire or a want of mercy to somehow stop this so she could survive. No mercy was shown. Her hope was extinguished, and it was done by the man seated in this courtroom. There's no doubt about that. It's been proven beyond reason. And now, he needs to be held to account for what he did. Now, he needs to be punished. And in making that determination, you apply the law that the court just gave to you, and you make a determination as to which of those possible punishments he deserves. And ask yourself as you go through this process, have we met our burden, the state of Nevada? Because in order for a sentence of death, the jury must find unanimously and beyond a reasonable doubt that at least one, it just takes one aggravator, at least one aggravator has been proven beyond a reasonable doubt. And then you make a determination. Each and every juror determines that the mitigating circumstances or circumstances, if any, which he or she has found, do not outweigh the aggravating circumstances. So you make that determination. We have to prove the aggravation beyond a reasonable doubt. The mitigation does not have to be proved beyond a reasonable doubt. But you have to ask yourself, the mitigation, does it outweigh what's happened? Does it outweigh these aggravators? And then you make a determination, if you make the determination, unanimously, that the mitigation does not outweigh the aggravation. He's eligible for that. So, let's go through that. Aggravator number 1, to prior crime of violence. Have we established beyond reasonable doubt a prior crime of violence? That's the robbery of Frederick Henderson. 1983, the facts in 1983. Late at night, this 73-year-old tourist in town from LA is gambling at the El Cortez. He decides to go up to his room where his wife and the couple that his wife and he came to town with is already up in the room, and the defendant sees him. The defendant preys upon him. The defendant follows him. The defendant gets in the elevator with him. This 73-year-old man, and you heard how he had a cane, and pushes him into the door as he's trying to get into his hotel room, takes his wallet, and flees. That Mr. Henderson goes to the hotel, and he's able to tell them who this was that did it, and then the hotel knows who he is. Goes and gets him, brings him, and Mr. Henderson identifies him. And ladies and gentlemen, is that something that's been proven beyond reasonable doubt? Absolutely. The defendant pled guilty to it. That's the judgment of conviction. That says, in a court of law, there's a judgment of conviction, a piece of paper that says he's convicted of robbery. Now, is that a crime of violence? Well, you just heard the judge describe to you what the definition of robbery is. It's taking property by means of force or violence or fear of injury. The testimony that was read in, Mr. Henderson, was pushed down. That's violence. This is a crime of violence. You have a verdict form at the end of your packet there. There's sections 1, 2, 3, 4, and 5. We're going to focus on section 1. That's the aggravation. The establishment of the aggravation. There's the form. There's the one for Mr. Henderson. Check the box. It's been proven beyond a reasonable doubt. The defendant pled guilty to it. And it certainly is a crime of violence. He pushed that old man down on the ground and took his wallet. He went to prison for that, ladies and gentlemen. This whole rehabilitation concept, you heard from the warden, you heard from Dr. Reutman, he had a chance at that. He went to prison. Did he learn from his time in prison, ladies and gentlemen? Did he change his ways? We've heard this concept of changing. He goes to prison, he's released from prison, he's on parole. Just as parole is ending, we get to aggravator number 2. Again, crime of violence. This is the incident, the battery with a deadly weapon against Angela Howell. This is 1986. This is eerily just a little over a month before what happens to Karen. The defendant gets off parole, just barely off parole, and what does he do after he's learned from that rehabilitation process? He goes right back to his criminal behavior, to his violent criminal behavior. And what does he do? He ups the ante. We're not talking about a push. We're talking about a pistol whipping of a woman. She's just trying to get into her car outside of the restaurant she was in to go meet her friends. Taps on the window, points the gun at her. And then he tries to actually tell her to open the door, like she's going to let him in. She tries to keep him out. He tells her, I'll blow your head off. Don't think I won't. It seems like the rehabilitation process is really taken. It's stuck deep inside of him. He's learned. She tries to push the gun away. Please don't do this. Please get out of my car. Begging for mercy. Was mercy shown by the defendant? I don't want to hurt you, I just want your money. Oh, maybe she's thinking, maybe, like that hope for that sunrise that Karen was hoping for. Maybe he'll stop. Maybe if I just give him the money. After she takes her hand off the gun to give him what he just said, he calls her a bitch and pistol whips her. And the gun goes off, blowing out the window to that car. But for the grace of God, Angela's not dead. She goes to the hospital because remember she had injuries she had to have taken care of. The defendant's caught, brought to her. She identifies him. This is aggravator number 2. Did we prove it beyond a reasonable doubt? There is the judgment of conviction. Battery with a deadly weapon. He pled guilty to it. It is established beyond a reasonable doubt. Is it a crime of violence? That's what it has to be to fit. It's the unlawful use of force or violence against the person of another. We know it was violent. She got hit in the head. She had to have stitches. That's violent. That is aggravator number 2. Go back to section 1 of your form, and you can check the box. There's the second aggravator. Proven beyond a reasonable doubt. We just need one in order for him to have to face the death penalty. Establish one. We've established the second one. Let's go to the third one. Now, keep in mind, when he did that, he had just finished parole. So what he did to Angela, he had just finished parole for Mr. Henderson. Then he gets arrested for Angela's, and you heard the testimony, he made bail. He made bail on the charges that he was facing for Angela. And what did he do? He learned from his behavior, right? No. It brought us to aggravator number 3. Now, the killing of Karen itself is not the aggravation. It's the way in which he killed her. It's how he did his dirty work. It is depravity of mind. There is a definition as to what depravity of mind is, and it includes to alter radically so as to make imperfect. Did the defendant alter radically as to make imperfect Karen? Now, when you're making that determination, understand that the mutilation, what he did to her, that can happen during, before death or after death. But the actual mutilation is beyond the act of killing itself. It is injuries and damage to her body that's not causing the death. It's beyond the act of killing itself. 45 stab wounds. We have to go through this to show how this is beyond the act of killing itself. You heard from the autopsy report, it's in evidence. You heard read into evidence the doctor who actually performed the autopsy, her testimony, Dr. Hollander. Blunt laceration trauma to the skin on the left side of her head. A knife wound to her back. 8 stab wounds to the top right side of her head. To the top right side. 8 stab wounds to the back of the neck. 8 stab wounds to the front of the neck. There was 1 stab wound behind her left ear. 8 stab wounds to the left breast. 8 stab wounds to the right breast. And ask yourself, this should be going through your mind, is this beyond the act of killing itself? 3 stab wounds to the abdomen area. 1 above the waistline that went into her liver. 2 on the left side of her abdomen. There's now the defensive wounds on her left arm and her right hand. He turned her into a pincushion, stabbing her 45 times. Going through those injuries to distinguish between those that caused her death and those that are beyond the act of killing itself, what was the testimony from the doctor? Could you tell me what your internal examination disclosed that's of major importance in this particular case with reference to any of these knife wounds? This was the testimony read in of Dr. Hollander. She's the one who performed the autopsy. Answer: yes, the knife wounds in the front of the neck penetrated into the muscles of the neck, and 1 penetrated in between the 3rd and 4th cervical vertebrae, going in between the 2 and reaching the spinal cord, causing hemorrhage. So 1 to the front of the neck gets her spinal cord. The stab wound to the chest on both sides penetrated into the lungs. There was also 1 stab wound in the back which penetrated into the lung from the back. The stab wound of the upper abdomen penetrated into the liver. Those were the major internal injuries. Now the cause of death. The information about the wounds, both external and internal, that you have given to us, was the information sufficient for you to render an opinion as to the cause of death of this individual? Answer: yes. And what was the cause of death? Listen to specifically what she says and put it in context with the other things that she said. The cause of death was multiple stab wounds of the neck, the chest, the back. Could any of those alone, or did all of them together cause the death? All of them together caused the death. That's referring to the injuries that she just indicated were the cause of death. The neck, the chest, the back. Was the cause of death homicidal in nature, in your opinion? Answer: yes. Would you exclude accident? Answer: yes. The injuries to the neck in the front, she testified to. The injuries to her chest. The injury to her back. Those are the cause of death. Now, to alter radically, to make it perfect, must be beyond the killing itself. What was beyond the killing itself? You heard about the defensive wounds. Now someone puts their hands up. There's a defensive wound on her right hand. There's a defensive wound on her left shoulder. Those don't cause her death. That's her just trying to survive through the night, to make it to the next day. Non-vital injuries beyond the act of killing itself. The top of the page, it says the other stab wounds penetrated into muscle. This is the doctor's answer. Into muscle which caused hemorrhage, but did not penetrate into any vital organ. For instance, all the stab wounds on the back of the neck, on the top of the head, only penetrated the skin, did not go into the head. Those didn't kill her. Those are injuries beyond the act of killing itself. What did not kill her? Well, we just heard the doctor say the top right side, 8 up to her head. 8 to the back of her neck. Defensive wound on her left arm. Defensive wound on her right hand. Cut to the back of her ear, abdomen. Those are the injuries beyond the act of killing itself. And then there was also this. Look at that diagram, ladies and gentlemen, and ask yourself, where's her abdomen? That's her belly button. Where's her abdomen, and where's that injury? Now, I'm not a woman, and I'm not trying to offend any of the women on this jury, but I dare say that if you had something, or a woman had something stabbed that close to her vaginal area, she'd probably say, yeah, that's not my abdomen. And we understand that it didn't go in directly. They had to shave her pubic hair in order to be able to show where the wound was. That wasn't her abdomen. Expert testimony, instruction number 22, it's in your packet. And I say this because I want you to put in context the testimony you heard from Dr. Coates. And later on we'll talk about Dr. Reuter. You should consider such expert opinion and weigh the reasons, if any, given for it. You are not bound, however, by such an opinion. Give it the weight to which you deem it entitled, whether that be great or slight, and you may reject it if, in your judgment, the reasons given for it are unsound. Dr. Coates said that was her abdomen. That was not her abdomen. And the actual autopsy report, which is in evidence that you have that you can read, says stab wound 28 was just above the left labia majora and penetrated into the soft tissues of the external genitalia to a total depth of approximately 2 1/4 inches. It entered outside, and when it went deep inside, made it there. Well, what's the big to do, right? Abdomen, non-abdomen. Ask yourself, is that altering radically? Is that making imperfect? Is that beyond the killing itself? How to grade it to put a stab wound on a woman's body like that? That didn't kill her. That's depravity of mind, ladies and gentlemen. That's what she looked like before he got his hands on her. That's the radical altering that occurred after the defendant got his hands on her. Lethal and all the non-lethal injuries. All the acts beyond the killing itself. And remember, this is just barely a month after pistol whipping Angel. While he's out on bail, facing those charges. Has it changed? And that's after he just got out of custody for what he did to Mr. Henderson. That's your verdict form. Again, the third aggravator on the verdict form is section 1, depravity of mind. Now, it gives you instructions from sections 1 to go to 2 or go to 3. Look at those instructions, and it says here, if you answered yes to any of the above aggravating circumstances, go to section 2. Well, the answer is yes as to all 3 of those aggravators. So you go to section 2. Section 2 of your verdict form, you've got it there. That's the mitigation. Those are all the things that are put forth as possible mitigation. Something you can consider in determining what's the appropriate punishment. Now, instruction number 8. The defendant has alleged that certain mitigating circumstances are present in this case. Just because it's in the packet doesn't mean that that's a finding that those are mitigators. You decide if it's a mitigator or not. Because whether a mitigating circumstances or circumstances are found to exist is your decision. Just because it's said to you doesn't make it yours. And let's go through some of these and ask yourself, is this really a reason why his punishment should be reduced? Some reason why he should get less than the maximum punishment for what he did to Karen? Because he started using marijuana in the past for self-medication? I'm confused. We're going to give a benefit, a mitigator, a benefit for criminal behavior. Because not back in 1986, smoking marijuana, that's a crime. And why are we going to reduce his responsibility because he started smoking marijuana? There's a lot of other ways to deal with the problems that he had, or the difficulties in his life. Going to criminal behavior and smoking drugs is not a reason to...
That was the beginning of the state's closing argument in the John Valerio case. The jury has the case right now. We have no clue how late they will be deliberating, but when they get a verdict, we will pass it along to you immediately. Michael Starr Hopkins is still along with us here, and there's one line we kind of keyed in on in that whole discussion, which it's got a lot of the dry law in it, but it's the prosecution walking the jury through how they want the jury basically to decide the issue. The prosecution has to argue the law. It's not just an emotional argument, but there was one line in there that got slipped in. The prosecution said that this defendant turned the victim into a, quote, pincushion. And I just sort of cringed back from the computer because that's the line that jumped out at me. It jumped out at you as well. Do you think it was too much, or do you think it worked?
I think it was too much. A lot of times you'll see juries punish, I don't know if that's the right word, but in effect punish prosecutors when they try to be flippant about the injuries that a deceased individual receives. You know, those kind of comments, especially when the family is in the room, come off as insensitive and a cheap trick. And so I could see members of the jury not really appreciating that kind of comment and really not seeing it as a effective tool of the prosecution.
Do you think one of the hardest jobs a lawyer has, no matter whether it's civil litigation or criminal litigation, is to deal with bad facts in a gentlemanly or a ladylike fashion?
It is. It's tough, especially when you have cases like this, where someone's life has been lost. There's a brutal nature, and you want to balance the line of really going after someone and turning those bad facts into good facts, but also not look insensitive. And so I think every lawyer tries to balance it, and that's why voir dire is so important, because you learn so much about the jury there, and you learn so much about their tendencies, what they like, what they don't like, and I think that's really, in a lot of cases, where you win or lose a case.
I'm reminded of a line that my trial advocacy professor used to use with my class in law school, and I think it's a good line, so if you want to steal it from this moment henceforth and use it. She said, no matter what side you're on, and no matter what case you're on, you always have to wear the white hat. You have to be the good guy, because if you try to get snarky as a prosecutor, or you try to oversell your case, you don't look like you're wearing the white hat. Meanwhile, if you're a defense attorney, you need to deal with the facts that you can in an ethical way. You can't hide the bad ones. You need to play up the good ones. You need to look at alternate theories of the case. You need to be an advocate for the truth. And that's wearing the white hat. And the best cases involve attorneys on both sides always wearing the white hat. I think that that's a good euphemism for what really should be going on. And sometimes we snicker at some of these lines, but sometimes I cringe, because we've had cases where I've gone on the record with everyone before and said, look, I think the prosecutor's overselling the case. This is going to turn into a mess. And then the jury hung on that particular case. Not surprisingly, because a lot of the jurors are probably looking and saying, is this really as bad as he says it is? Because I'm not seeing it. Well, the theory of the case is off then.
We saw that a lot in the Casey Anthony trial. Prosecution came in and they oversold the case during the opening arguments, and the jury was never really able to take the facts and the information they had and match it with what they were promised at the beginning of the trial. Talking about law school, I had a professor who had a similar kind of euphemism that they used. All facts are good facts. It just depends on how you look at them. And I think that both sides, what your end goal is to take the facts that you have, and no matter how harmful or helpful they are, give the jury the ability to look at them from where your viewpoint is. I think that the most effective attorneys, the Johnny Cochrans and such, are able to take even the worst facts and flip them in a way where the jury can say, oh, I didn't really see it like that until you showed it.
Yes, I agree with that theory. It reminds me of something that I said as a journalist, which is that there aren't good news reports or bad news reports. There are just accurate and inaccurate news reports, and my goal is to be as accurate as possible. If you think that it makes you, quote, look bad, then my only question for you is anything that I said inaccurate?
Exactly.
If you drove drunk, crashed your car, and hit somebody, then what's inaccurate about it? Or whatever the facts may be. You lost the election. Your school administrator was taken out on corruption charges, whatever it is. I can't really look at it as a good thing or a bad thing, or positive or negative. It's either accurate or inaccurate.
You have to have the trust of the jury. And as soon as you lose that trust, you've pretty much lost your case, because whether you're on the prosecution or the defense, whoever gets the jury to trust them the most is going to be the side that usually wins. And especially when you're talking about this kind of case where, we're at sentencing now, whether you can get the jury to trust you and believe that you're being authentic is going to be the difference between potentially, the defendant getting out and possibly being paroled, or, the defendant receiving the death penalty.
Yes, exactly. So, final thoughts on this. I know you need to run soon. Overall, do you think that the prosecution sort of towed up to the line, or do you think the prosecution edged across it just a little bit.
You know,
They went a little bit too far.
I do. I think they tiptoed just barely over the line. I think that I don't know if I want to use the phrase lucky, but they're fortunate because given the nature of these crimes, I think the jury will be more forgiving of tiptoeing on that line because of the 45, I believe, stab wounds, the vicious nature, some of the sexual aspects of the crime. I think that they have more room to tiptoe over that line, but I think that the jury is going to be cognizant of the fact that they stepped over that line.
Yeah, again, it's bad to oversell a case, but we'll see what happens. Michael Starr Hopkins, attorney, always nice to see you again. Come
Thanks
back and
so